Hi folks, and welcome back to Contract Law. This is the video series on vitiating factors, and these videos will look at illegality. And we jump into the Prezi, and let's have a look at our overview. Illegality certainly sounds like a fairly simple concept, doesn't it? Arose in the 18th century, 1775, in fact, in a case called Holman and Johnson. And in that case, it was found that no court will lend its aid to a man or a woman who founds their cause of action upon an immoral or illegal act. Okay, sensible, for sure. However, this branch of contract law has proved fairly challenging, and in fact, Carter calls it one of the least satisfactory branches of contract law. So, a little bit of a challenge, few curly twists and turns here. However, we will certainly get some satisfaction in terms of clarity if we break it down in some fairly simple ways. Firstly, we'll have a look at illegal contracts, and then we will have a look at void contracts. And right from the get-go, I want you to keep those two conclusions about the status of a contract very separate in your minds. Part of the difficulty in this area of law is because judges tend to use legal terms of art like the conclusion of the status of illegality or the conclusion that a contract's void. They use the terms kind of interchangeably when in fact perhaps they shouldn't. And it's not terribly helpful for law students. So we'll break them down, keep them nice and clean and neat. We'll look at illegality first, and then we'll go ahead and look at void contracts. There are some fairly significant differences in illegal contracts as compared to void contracts, and we'll talk about that in just a moment. So the first thing to bear in mind is that there are two sources of potential illegality, or two sources of a contract being found void: statute and common law. It can sometimes be a simpler exercise to work out whether a contract is illegal or void under statute, but sometimes not. So these are the two separate streams of authority that we need to classify our discussions around. And there are two potential results, as I said, illegal and void. So here is a snapshot of the consequences of a contract being found illegal and a contract being found void that I just kind of want you to bookmark and keep in your mind as we go through. We'll be talking further about the effect and the consequences of illegality, or the consequences of a contract being found void, more later on in the video series. But just for now, here's a snapshot for you to keep in mind. If a contract is found illegal, the consequence is ex turpi causa. That's a Latin phrase, awful phrase, but it simply means that courts will generally deny relief. You can't sue on an illegal contract. That means that you can't recover back monies that have been paid over or property that's been transferred over. Okay, nasty. However, the illegal contract might be effective to actually pass title over, which is certainly important for third parties at the end of the line that might have received property that might have changed hands under an illegal contract. And the offending illegal provisions might be severed. So that's kind of the snapshot of illegality. In terms of void contracts, quite a different scenario here. There's no equivalent sanction of ex turpi causa. Okay, the contract itself is non-existent as between the parties. So if you recall discussions around, for example, the vitiating factors of mistaken identity or non-est factum, those kinds of vitiating factors will have the result that the contract itself is void. That means because it's non-existent, title cannot pass. So the third party down the end of the line, if they receive property or money or that kind of thing, they're going to be in a very disadvantageous position, aren't they? However, a void contract where money has been, or property has been transferred over, you might be able to recover that in restitutionary actions. Okay, so they're the contrasts that you need to bear in mind. Now, unfortunately, there's a little complicating factor. It's somewhere in between the two extremes of a contract being found illegal and a contract being found void is this notion of unenforceability. If a contract is unenforceable, it simply means that you can't actually sue on it. You can't run off to court and try and enforce your rights. However, it hasn't got the stigma of illegality. There's no penalty or sanction, for example. There's no consequence of extra causa, but it might be effective to pass title over and therefore through and on to third parties. So just bear these consequences in mind as we move through. As I said, we'll be talking more about consequences in just a moment. So that is our overview of illegality. Looking first at illegality via statute, the High Court in Nelson & Nelson identified 3 different kinds of illegality via statute. Firstly, where the statute expressly prohibits the making of that kind of contract, obviously express illegality. Secondly, where the Act prohibits the doing of an act that is contemplated by the contract. In that case, there's going to be implied illegality. And finally, where the contract is aimed at furthering a particular purpose which runs against or counter to the public policy that surrounds the Act or the statute that is at issue. So we'll have a look at each of these in turn. Looking first at express illegality, this is the easy peasy one. The Act itself spells it right out there in the text. It says these kinds of contracts are prohibited, and it normally also helpfully tells you what the precise consequences will be. If so, happy times. So in Baird and Magripolis, Baird subleased some land to 2 Greek fellows by the name of Magripolis, and unfortunately they were not very fluent in English. The sublease itself contained a condition subsequent that required the Magripolis fellows to either become naturalised or to pass a dictation test in English. So the contract would have fallen over if one of those events hadn't occurred. The Magripolis fellows went and spent quite a fair bit of money on the land. They thought that the sublease had been locked away because they'd become naturalised. However, the Leases to Aliens Restriction Act of 1912, rather pejorative title there, expressly prohibited agreements to aliens who hadn't passed the dictation test component, and it said that such agreements would be void. Aha! So, in the dispute as to whether or not that sublease was valid or illegal, it was actually held, obviously, because the Magripolis fellows had not passed that dictation test. The contract was expressly illegal via statute and obviously null and void. So that's express illegality. Another case that the text discusses there is Re Mahmood and Isfahani. Something similar to this one. Looking next at implied illegality, this is a little bit trickier, obviously, because it's not all spelled out for you nicely in the legislation. So you need to do a bit of a forensic digging around in the Act and its text to work out whether you can imply from the sum total of it that the contract should be prohibited and therefore illegal. If there is an objects clause, go straight to the objects clause. So what you're trying to get at is what the Act is directed at, what the legislation is designed to achieve or protect, for example. If the object can only be achieved by prohibiting a contract, then that's what Parliament will have intended. If it seems like a contract should be prohibited by any particular piece of legislation, you've got to explore the legislation quite thoroughly. So you need to look at things like penalties. Is there a penalty set down in the legislation? How severe is it? Is it structured on a daily basis, monthly basis, per transaction? Is the prohibition, that is the loss of contractual rights, is that an unwarranted additional penalty that's over and above the penalty that's already set down in the legislation itself? Are there issues of public safety? Would the result of illegality be disproportionate to whatever purpose was set down in the legislation? Does it go over and above? Is it over the top? If it is over the top, then it's unlikely that a court will actually declare a contract illegal as implied by that legislation. So if the prohibition is not necessary, it won't be prohibited. Prohibition is a really serious deal, so courts will look very, very carefully at this kind of thing. A good example of court discussion around the issue of implied illegality is the Gengo Pastoral case. And in that case, classic scenario of a plaintiff providing the defendant with a loan, the defendant defaulting, and the plaintiff trying to sue to get their money back, and the defendant trying to get out of the whole arrangement via the escape route of illegality. In that case, the Banking Act was the focus of the decision, and that prohibited any banking business in Australia unless the person or company had the relevant authorities set down by the legislation. The penalty was pretty steep. As you can see there, $10,000 per day. So the question was, could the plaintiff enforce the agreements despite the fact that they didn't actually have the authorities as the legislation required? So the court looks very closely at the Act, and in particular the penalty provisions in the Act. They said, have a look at the way the penalty provision is structured. It's not actually, the penalty is not imposed per contract, per each unauthorised contract that the business carries on or that the business concludes. The penalty is imposed upon the business for each day it carries on its unauthorised business. So they said the intent of the Act was to restrict and control the business of carrying on banking rather than a minute prohibition on each unauthorised contract. So that was a big factor in the court's decision. The other thing that played on the court's mind was that to prohibit all contracts would have been gravely inconvenient and an additional injury to innocent parties. All sorts of other contracts would have been affected, employment contracts and the ability to pay depositors back their money. All of these things would have been an unintended and very unfortunate consequence of declaring all of the business's contracts illegal. So no prohibition in that case, no implied illegality. You might find that if the legislation has public safety or public protection as part of its object, then a court will be far more ready to find a contract impliedly illegal. In Pretorius and Muir, for example, there was the sale and purchase of therapeutic goods, and they were controlled by the Therapeutic Goods Act. Obvious issues of public safety there. The contract was impliedly illegal. In Cope and Rollins, similar issues of public protection where the legislation was aimed at regulating financial brokers, financial intermediaries, and implied illegality also found there. So that's implied illegality. The next issue to look at is illegality via public policy. That is, the contract runs contrary to some kind of policy that underpins the legislation, so it's not expressly prohibited, it's not implicitly prohibited, but the policy that underpins the legislation really would dictate that the contract should be declared illegal. The main case in this area to look at is the Fitzgerald and F.J. Leonhardt case. If you're going to look at a case in this area this week, I'd encourage you to look at this one. It's a very clear and a helpful exposition of the principles in this area by the High Court. In that case, we had an owner that engaged a driller to drill a bore. This whole exercise was regulated by the Water Act of the Northern Territory. That act required drillers to be licensed, and it also required owners to get permits to construct bores. Obviously, water being an important resource up in the Northern Territory, a very dry geographic location, the government wanted to ensure that that resource was appropriately controlled and restricted. In this scenario, we had the driller being licensed to conduct the activity. However, the owner had not obtained permits to construct the bores on their property. Nevertheless, the driller did their work, and then the owner tried to get out of payment by saying that the whole contract was illegal because they didn't actually have a permit to construct the bores on their land. Perhaps unsurprisingly, given the owner's conduct in that fact scenario, it was held that the defence of illegality failed and the driller was allowed full recovery. As I said, the court engages in some fairly helpful discussion of the principles around illegality via statute. Here, we didn't have a case of express illegality. Very clearly, the Water Act did not say all contracts are prohibited wherever the parties fail to have the correct permits. Interestingly, the owner that was trying to get out of payment did not plead illegality, implied illegality. So McHugh's decision, joint decision, actually notes that the Act did prohibit the owner doing acts without the authority of a permit, and an agreement that the owner engage in such activity may have been treated as impliedly prohibited and therefore as illegal. However, that is not the owner's case. So potentially, had the owner pleaded implied illegality, they may have got further than they did, but in any event, they pleaded illegality via public policy. What did the court look at first? The legislation here vested in the Northern Territory Government the property right to use, the flow and the control of water. As I said, a very important resource there. The property owner's rights were subject to the Northern Territory Controller's right to impose restrictions. The licensing systems operated in aid of the statutory scheme for controlling this very precious resource. And the controller had to weigh up various factors before the permits could be granted. Now here, the driller, the person that had done all the work and wanted to be paid, had actually done everything necessary. They complied with all the licensing requirements. Their claim for payment was not associated in any way with the owner's lack of permit, with the whole illegal part of what went on. So the imposition of a sanction of illegality here would mean, obviously, that the driller would be denied payment, and it would be disproportionate to the seriousness of the breaches of Section 56 and would be unnecessary to protect the objects or policies of the Act. So not illegal. The poor old driller could actually recover their money. The owner couldn't rely on their own failure to get out of payment via, as I said, the exit route of illegality. So a very interesting and useful case there to flesh out the notion of illegality via public policy. There is a sneaky fourth one that I thought I'd slip in here just for completeness, and that is illegality that attaches not to the formation of a contract, but to the performance of a contract. So in Gengo Pastoral, you have the High Court basically discussing this fact. The three categories that we've just looked at, illegality via express prohibition, implied, and contracts contrary to public policy, are all instances of illegality attaching to the contract as it is formed. However, you might get a contract that's perfectly valid and legal on its face, but the way that it's performed is the problem. A good example of this is the Ashmore Benson Peas & Co Limited and A.V. Dawson case. In that case, there was a contract to truck 2 lots of 25-tonne tube banks to a port for shipping elsewhere. That contract was perfectly legal on its face. The problem was that the defendant and later on the plaintiff were both aware that the defendant intended to use their trucks that could only carry a 20-tonne payload, and that was obviously illegal under the Road Traffic Act. You guessed it, the truck turned over while it was carrying these very large tube banks and caused the plaintiff loss. Now, the plaintiff then sued to recover their loss from the defendant, but they couldn't because the contract was illegal as performed. Both parties were in pari delicto, and we'll talk about that in just a moment, but both parties were equally complicit in the fact that these 20-tonne trucks were going to be used for a 25-tonne payload. Obviously, you can't recover in those kinds of circumstances. So that's illegality as to performance. There's one other small issue, and that is kind of a de minimis issue. If you've got incidental illegality, it's not really going to be a problem. So if there's no real problem with illegality in either the way the contract was formed or the way that it was performed, but there's just something around the edges that is a problem so far as legality is concerned. For example, in the Ashmore Benson Peas & Co case, if 25-tonne trucks had been used, that would be a contract that was legal as formed, legal as performed. But if the truck had been speeding along and had been caught by a speed camera, that would be an incident of incidental illegality. Not really a problem there. Have a look at the St John shipping case that your text talks about. So that is illegality via statute. However, we've passed the 15-minute mark, so I'll end this video here and I'll go across to video 2. And until then, bye for now, guys.